Hello, everyone. My name is Okundai Mary Cynthia, an associate at Bonisa Bakabalibo. Today, we're going to be talking about the pitfalls and controversies in the Land Use Act, and of course, possible solution. Here with me is one of our senior associates, Mr. Diner.
Thank you very much, Cynthia.
You're welcome.
My name is Rubin Chukwulibe, a senior associate in Sambakaba Legal.
Welcome, Mr. Diner. So, can you give a brief background to the reason you're discussing this?
First and foremost, the Land was actually enacted on 29th of March 1978. And if you do your calculation, we find out that a few days ago, just 3 days ago, when the Land Use Act clocked 45. So you're in the out of place to say happy birthday to the Land Use Act.
Yes.
So basically, for those of us that are following the controversies that were being deliberated by the Land Use Act, we find out that the Land Use Act is a statute of unique importance. And in fact, and astounding, it is the most impactful legislation touching on land administration in Nigeria. And it continues controversies. So when you look at the Land Use Act, the aims and objective of the act, it's so blurry. And the fact that the land is very important to human existence, absolutely, makes it more all important. So that is why the land would have been greeted since the enactment with controversy. And I recall, as a law student and an avid land law student, I read papers and works of renowned professors and of international and distinct reputation. Some of them like Professor Mutala, Professor Giles, Professor Ayu Sweets, Professor Nekashian, to mention but few. These are professors, renowned professors of law, that at one point in time, and to give their opinion or to try to resolve this growing controversy surrounding the Land Use Act. And so, first, before the Land Use Act was promulgated, there was yearning from the people. Nigerians were crying for a system of land administration that is people-oriented. And before then, the land, or rather, the government ceased not to be in control of land administration in Nigeria. So the government, in order to seize control of the land management system in the country, needed something drastic and something holistic. And that is why the government came up with the Land Use Act. Just as I rightly identified, prior to the enactment of the Act, land was relatively in the hands of few individuals, and the government could not access this land for development purpose. I know in modern society, I know how to enable government to achieve their political manifestos and their plan for the country. They need to have a better access to this land, and then these lands are not readily available. And when they need this land, the holders of this land sell this land to them with a very high price. That is, if they are willing to sell. And most times when they don't want to sell, the landlord, the government is left without any option. So there was need to now bridge the gap between the rich and the poor, and to ensure that the land is equitably distributed among all Nigerians, so that everybody will have access to this land, particularly in line with the provision of the Constitution. First, the right of every Nigerian to own land in any part of this country is recognized by the Constitution. So Section 48, so which is Section 43 and Section 44 clearly gives us, or Nigerians, the right to own land. Hence the need to have something that is drastic, that will recognize the rights of Nigeria and lead the government to have access to this land to enable them provide for the people.
That's really interesting. Thank you for giving such, outstanding background to the reason you want to talk about this. I can imagine that the, enactment of the Land Use Act was for the good of the government and for Nigeria at large. So I want to, now that it has been enacted, we now have issues with what the government has enacted. So I would like to ask, what are the issues that you have identified in the act?
Well, thank you, Cynthia. The Land Use Act, when you look at the Land Use Act, particularly the preamble, we find its aims and objectives. The preamble can then completely or strictly state that the Land Use Act is promulgated to ensure that land rights of Nigerians preserved in sufficient quantity to enable them to provide for the sustenance of themselves and their family. So you find out that the objective of the land is people-oriented. So now, unfortunately, even though this Land Use Act is a statute of unique importance, even though this Land Use Act is so important, but when you look at its provisions, you'll find out that the provisions are mostly undemocratic principles that are not suitable for modern societies. And that is not to say that the Land Use Act or the provisions of the Land Use Act is not laudable. Some of the provisions of the Land Use Act can be found at reasonable as civilized society. So when you look at Section 1 of the Land Use Act, the Land Use Act vested land ownership or title to land on the governor of each state. For the governor to manage this land for the goods of the people. Yeah. So more or less, it's created what is called a trust concept. Well, I will say that it's a trust concept in the strict sense of the word. Stricter because I don't think the governor should act all. Rather, the governor is meant to account to anybody on how he administers land in the country. So, with the investment of the land in the governor, you find out that rather than reaching out to the people, but rather than ensuring that the administration of the land is done to take care of the people they seem to represent, you find out that the Land Use Act brought short of these obtainable standards. So first, addressing this issue of where the problem originated, the Land Use Act was promulgated in 1978. That was during the military regime. So the mindset of the draftman was that the Land Use Act was to only operate during the military regime. It has no business still being in place in the government under the civilian or democratic rule. So that is why, casting my mind back, the members of the Constituent Assembly of the Land Use Act panel that was set up to review the Land Use Act, and it was the draft constitution of the 1979, clearly stated that the Land Use Act will be repealed once the military hands power to a civilian government. So the military were so intelligent in order to ensure that they have this effective control, because you don't have a military rule. The military is more or less a unitary system where just one man sees at the same time just call the shots.
Yeah.
So I want to give the military this effective control and to ensure that it is deeply rooted and law. When the 1979 Constitution was promulgated, the Land Use Act was installed inside the Constitution, meaning that the Land Use Act, from that very moment, it became part and parcel of the Constitution. And that is why it has been very difficult to amend the Constitution.
Yeah.
So, you ask yourself, having come into the civilian setting, how come the Land Use Act functioned to go this way? No amendments since 1978.
That's is funny.
So, if I interest you to know, even the subsequent Constitution, like the 1999 Constitution, equally created a special place for the Land Use Act. I want to believe that this is pure for the selfish purposes or selfish aim of this government, because these are the same governments even before the Land Use Act was promulgated. They keep saying that upon its coming into effect, all the military hands over, the land use act to be repealed. For they came and they found comfort in the land use act purely because every Nigerian naturally loved being in a position of authority. They feel that it's a veritable tool for them to realize their political agenda or manifesto. So when the Land Use Act was enacted in 1979, it was incorporated into the Constitution, particularly into the provision of Section 315 sub 5 of the Constitution. It listed some acts. One of those acts included was the Land Use Act. So the Land Use Act, if you look at the provision of that particular provision, it says, nothing in this Constitution shall invalidate the provision of this Act, and that the provision of this Act shall continue to have effect like every other provision in the Constitution. And it still went further. That the provision of the Land Use Act can only be amended in line in Section 9 of the Constitution. And what is Section 9 saying? Section 9 is the section that provides for the process through which the Constitution can be amended. And you all know how difficult it is to amend the Constitution.
Right.
And that is why it is difficult today to amend. Despite criticism, despite hearing for the Land Use Act to be reviewed to reflect the dynamic nature of the society.
So I can sense from what you've just said that, one of the ways to manage the excesses of the Land Use Act is to actually sit down, review this, and ensure that all the provisions that are needed are put out and all provisions that are not needed or do not apply is taken out. So I can imagine that you are saying, let the Land Use Act be reviewed. In summary, what you're saying right now. Okay, is there any other solution that you would like to prefer?
Yes. So just as I rightly said, with the promulgation of the Land Use Act and the incorporation of the Land Use Act onto the Constitution, the Land Use Act, by necessary implication, he gave an extension of the Constitution.
Yes.
And even when we know that certain provisions of the Land Use Act contravene the provisions of the Constitution, you cannot say anything, because you cannot, to be an aberration for you to say that the Constitution is in conflict with it. And that was what led to the decision, the famous decision, in Portia and Governor of Anambra State. Governor of Anambra State, where the Supreme Court was called to take a firm stand on the constitutionality or otherwise of the Land Use Act. And interesting, the Supreme Court said something very profound. The Supreme Court, while recognizing the fact that the Land Use Act has been incorporated into the Constitution, stated that notwithstanding the incorporation of the Land Use Act into the Constitution, the Land Use Act continued to remain a mere legislation, just like every other act of the National Assembly. So what the Constitution simply did was to elevate the status of the Land Use Act, and that is what the Supreme Court said. But the Land Use Act is merely an existing legislation that was made extraordinary by virtue of its entrenchment in the Constitution, and that whenever there is conflict between the provision of the Constitution and the Land Use Act, the provision of the Constitution will prevail. This position of the courts is more or less, I would call it a judicial rascality, because it tends to bring in human collaboration into the Land Use Act. Because assuming the Supreme Court has held that the Land Use Act forms, or rather, part and integral part of the Constitution, then the Land Use Act at full time regarded as supreme, just as the Constitution is. And whenever we have controversies, particularly provision that tends to violate fundamental human rights of Nigerians, so the Supreme Court at that point wouldn't have much to say. So with that decision, the place of the Land Use Act has been determined. Now, looking at all the solutions to this problem, when you look at the Land Use Act, the Land Use Act made provision for two major components. First is the power of the governor to revoke right of occupancy for overriding public interest. However, subject to the payment of compensation. So when you look at the process for achieving this lofty objective, I'm not saying that the power of the governor to revoke land is bad. In fact, the principle it upholds is obtainable in every civilized society, even in the UK, in the US, in China, and in India. But the problem here is the approach through these rights of the governor is being realized. Yes, the Act clearly says revoke the right of occupancy for overriding public interest, however subject to the payment of compensation. You ask yourself, is this veritable tool in the hand of the government being used to actually drive the objective of this act? Here says law. Most often than not, this power is being used as an instrument of political victimization, and sometimes a means of rewarding political loyalty. And that is why when these lands' rights are being revoked, you find out that there is no plan on ground. Because when you look at the land, it says, of all the issuance of the notice, the land rights resting in that of the individual stands revoked. Upon the issuers of the notice, you're talking about taking the rights of Nigerians from their ancestral home, right of Nigerians from the land from which they derive their means of livelihood, simply on the basis of a mere notice. That goes to show you that this system is actually meant to succeed in the military setting. So you still find that it's undemocratic. Also, when this land are revoked, you find that even after revoking this land, the land stayed there for more than 10, 20 years. The land will be there without being put into you for the reason why it is revoked. And that is going to show you that the government has no plan, but rather their primary objective is to punish the individual in whose favor the rights inheres. So the problem now is, you look at the procedure, just as I said, I'm not against the principle of the revocation, or what you call in some jurisdiction compulsory acquisition or compulsory taking. I'm not against it. So first, we look at the procedure through which this right to be exercised. Before the government should exercise this power, there is need for effective planning. The government must sit down, look at the land, see if the land is suitable for the purpose for which it is needed. Thereafter, the government will do what we call an impact assessment to look at the impacts of that particular project and the community. So, you expect the process. And when that is done, mind you, just as I said, these lands most often than not are ancestral lands of some individuals. These are lands where the people have lived for years. And you think that you can take away this land by mere issuance of notice. If the tenancy law could recognize the right of tenant, how much more the land is at, or to recognize the right of owners of land. These are land they were occupied from time immemorial. So what I would suggest, before that right to exercise, or rather to revoke that thing is, the right of occupancy is exercised, there will also be issuers of notice of intention to revoke. At that point, the reason for this particular requirement is to enable the individual whose right is being taken away to give them the opportunity to make their representation. If they have any objection to raise, if they have any of their challenges to raise, if they have any claim for compensation, these are time the government will need to decide these preliminary issues. Because the government, what the government does is when your right is taken, You're merely left with mere promise of payment of compensation and resettlement, which you will never see. So there is way to engage these people, not solely engaging the people whose rights you're taking. The major stakeholders, they have to consult far and wide to ensure that this process is right, is fair, and just. And that is why whenever this right is being exercised, the criticism or the protests against the government exercised of this right is always of the increase. Secondly, we talked about the issue of payment of compensation. One of the problems with this principle as providing the Land Use Act, because it makes the Land Use Act susceptible to breach. How can you make the payment of compensation a post-revocation process? When you take away my land and we leave it with mere promise, and at the end of the day, that promise is never realized, how do you want the other Nigerian to feel? Land is very important in human life. Take away land from the life of a man is left with nothing. And that reminds me of the words, a sheep. Sheep goated. He says something very profound. Then land belongs to the living, the dead, and countless years of above. The life of land starts and ends with the land. And when you deprive the individual of this right to land, invariably, you expose these individuals. Then the issue of compensation. If you look at the yardstick for measuring the payment of compensation, it says payment of compensation is limited solely to unexhausted improvement on the land. It means that for you to be entitled to compensation, there must be an improvement on the land. If you have a bare land, you're not entitled to compensation. Mind you, this land couldn't buy this land for free. We all know the cost of land in Nigeria. And they didn't just stop there. They said, unexhausted improvement. In order to assess what is due to the individual whose right has been taken. He said in order to assess this, what they look at, one, the unexhausted improvement, less depreciation, and then in the case of delayed payment of compensation, the individual is then entitled to interest at the prevailing bank rate. That does not to me sounds like enough deterrent to force the government to live up to their commitment. Because if the punishment for the government for delayed payment of compensation is simply payment of interest, don't call it bluff. Well, and that is why when we go to the courts are very consistent to stay there. The payment of compensation shouldn't just be paid properly. It must be sufficient. And one of the problems about the Land Use Act, which I need to point out, the Land Use Act created a body, an advisory body, called the Land Use Allocation Committee. The duty of this Land Use and Allocation Committee is to advise the governor on this exercise of this right of allocation, and equally to advise the governor on the payment of compensation. If you go further, the Land Use Act states, whenever there are disputes as to the adequacy or otherwise of the compensation paid to the individual, that the decision of this committee is final. But I thank God that the Supreme Court, in a portion of the case I cited, have resolved this issue because it's clearly unconstitutional. Section 48 gives an individual, gives Nigeria the right to own land. And it says this right cannot be taken away compulsorily unless prompt compensation is paid. And even when this compensation is paid, the individual still has the right to go to court to question the adequacy otherwise of the compensation. So you find out that this compensation is likely inadequate even when it is paid. And that's what we recommend. If you go to the US, the approach they use is the fair market value, meaning the value of the property in the open markets. But when you come to the UK, the standard view in the UK is the principal value to the owner, otherwise called the principal of equivalent. Here, they take into cognizance various ends of claim, because not just enough to take my land and you want to pay me compensation simply on the basis of the unexhausted improvement. So what about the land itself? What about damages flowing from loss of profits? What about injurious affection, damages from injurious affection? So you find out that the heads of claim beyond the damages suffered by simply taking the land is much.
Yeah.
So these are things that the government should start looking into. Beyond saying that the compensation is to be paid solely on the improvement on the land, that particular provision is undemocratic and doesn't take into cognizance the rights and pillars of Nigeria. And most times, the government of the day, in order to prevent or deprive citizens from this little compensation being paid, do everything within their power to frustrate the process. Because there are situations where the right can be revoked without compensation. That is what we call penal revocation. So what they do is not uncommon when you come to Lagos, where the governor will tell you, where's the certificate of occupancy for you to be entitled to compensation, for you to be entitled to the compensation. Ask yourself, how many landowners or the certificate right of occupancy holders have certificate of occupancy? Because the process of attaining or getting this document is so tedious and very expensive. And you ask yourself, the Land Use Act came in to bridge the gap between the rich and the poor. How many poor person can afford this process? So that's the very wrong thing for the governor or the government to do. I believe once you are able to show that you have sufficient interest in the property, you should be entitled to compensation. You should be entitled to compensation. So it is wrong for the government to say, show me your certificate. And these are some of the problems. You look at the other time we talked about the issue, or the own internet was about the issue of what the Magodo estates. And we heard about the issue about this famous pastor in Anambra State, Dumeje. In Magodo estate, the right of the locale where the land was revoked by the Lagos state government. The land, from what I read, belonged to the people of the Shanishal people, and it was conforming to Pitfall. Then, without following the process laid down by the Act, I know the Land Use Act, being an expropriatory statute, must be construed strictly. If you revoke it for overriding public interest or public purpose, it must be for the purpose for which it is revoked. Anything other than that amounts to what we call failure of public interest. So that was one of the reasons there. You look at the case of Odumeke, and you don't have sufficient facts. But you see the man crying, fighting, protesting, doing everything he can at the last minute to ensure he preserves his property. You saw the man crying, trying to do everything he needed to do at the last minute to resist the process. Some people will look at him as a Frenchman, but that depicts the attitude of a common man whose right to land has been taken. Well, do you think if the process was done effectively, do you think if he was properly engaged, I don't know if he had a valid right of allocation over the land? If he does, do you think that if he was effectively engaged, do you think he would fight the government or want to resist the process? Well, so you find out that this process are not done properly. And that is why when you revoke, you pay compensation.
So essentially, what you're saying is that the process of compulsory acquisition should be free, fair, engaging, and democratic. That's what you're saying in essence.
It's very well, very well. But I will not fail to conclude by highlighting the philosophical basis for payment of compensation, because it's very important. The reason why compensation is paid is to ensure that one man does not bear the responsibility of providing for the need of the entire public. So in order to show or not to make the process to be fair and ensure that everybody shares in the responsibility, that is why compensation is paid from taxpayers' funds. So once you compulsorily take away my property, I refuse to properly compensate me. What it then means that my interest has not been taken into consideration, and that automatically, as far as I'm concerned, constitutes a gross failure of public purpose, because my interest hasn't been factored in. So I want to believe that with this, the government will have to look at this land use act.
Yeah.
And I mean, the land use act, it is long overdue. It should be able to accommodate our democratic setting. Because just as I say, the system envisaged in the act is merely meant to work within the military administration. 1978 to date, 45 years now. So what I'm saying in this sense is I'm calling for the urgent review of the act. Sadly, out of the whole political manifestos that we read, that we had, the election has just recently concluded. A lot of them made mention of the Land Use Act. And this is very, very important. So I want to believe that with this will actually improve and actually bring to the notice of the government that the Land Use Act is not good at you and should be reviewed. So bring it in tandem with the young aspiration.
Yeah, but wow. This was such an enlightening and interesting session. And I know that, my guest here has brought light to this particular issue. Mr. Adina, thank you very much for being on this. I really appreciate it and really enjoyed the session. Yeah. Once again, my name is Akanaiwe Cynthia, an associate at Edisa Bakaba Legal. And you are?
We've been Chupulobe, senior associate with the Sabakaba Legal.
Yeah. Thank you.